Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in this video let us learn about interpretation of taxing statutes. Earlier we have learned about interpretation of penal statutes. What are the strict rules of interpretation for the penal statutes? Today let us learn about interpretation and strict rules regarding the taxing statutes. Strict rules of interpretation is one of the principles used to interpret fiscal, that is tax and penal statutes. According to this rule, plain, clear and direct meaning is given to the words which are used in common by the general public to which such law is applicable. There can be no presumption by the court with respect to a particular meaning. Court cannot give particular meaning to a word which is not clear by making a presumption that particular meaning is the intention of the legislature. So here what are the rules to be followed by the court to interpret these taxing statutes is it should go in a plain manner. What is understood by a common man should be interpreted in such a manner. So in this manner we have to apply some rules for interpreting taxing statutes. What is tax? Tax is nothing but it is a forceful extraction of money from the taxpayer by the sovereign authority, that is the government, in which the taxpayer is not entitled to any assured benefit. So taxes place a monetary burden on the taxpayer, and thus to some extent it is considered as penalty on the taxpayer, which is imposed under the authority of law. Thus, unless the imposition of tax is clearly backed by law, no tax can be imposed. Because the taxpayer feels it as a burden, he takes out the loopholes in avoiding and paying the tax. So, what are the reasons for applying so many strict rules on taxation statutes? Because taxation statute is a fiscal statute and is enacted on the basis of trial and error method or an experimentation basis, it is not practicable for the legislature to anticipate all the possible situations or what are the conditions which might arise after the law is enacted. So it is possible that the SSC, that is the taxpayer, might use some shortcomings in the law as a loophole and take advantage of it. As tax results in pecuniary burden, the benefit of doubt is given to the taxpayer in case of any contradictions. And the strict rule is applicable on taxation statutes, so courts are bound to give clear and plain meaning without going into the consequences which can result after applying these taxation statutes. So there is no presumption of tax by the legislature to impose tax unless clearly and specifically provided. Thus, it is the authority or it is the principle of the legislature or the subordinate authority to come forward and bring amendments and clarifications to rectify those loopholes. And because the taxation statute is a fiscal statute and it imposes pecuniary burden on the taxpayer, these statutes are to be construed strictly. And the courts should give plain, clear and direct grammatical meaning for that interpretation of those statutes. When there are two possible outcomes in that interpretation, and the one which is given in favor of the assessee or in favor of the taxpayer is considered. So any taxation statute involves three stages. Firstly, on what subject the tax is levied. Secondly, the assessment of the liability of the taxpayer. And lastly, the recovery once the assessment is made. Coming to the judicial approach. In the case of State of Uttar Pradesh versus Chorus India Limited, in this case the question was whether the carbon paper was a paper or not. The Supreme Court held that the common meaning of the term paper is not as same as carbon paper. Hence, these two terms are completely different from each other. Here, the words used in taxation law should have the meaning which is understood even by the general public in daily routine, and hence ones which is popular and which could be understood by the people to whom the law is applicable and familiar with. So here the court said that carbon paper will not be included in normal paper, so to make it subject to taxation. Here the taxation is levied on the carbon paper. In another case of Union of India versus Commercial Tax Officer, the goods were sold to the government department. Here the question arose that many such sales are happening and the government is exempted from paying sales tax. So the Union of India representing the Government of India department held that many other departments in Government of India were exempted from paying sales tax, and hence same consideration should be made in this case also. Then the Supreme Court said that no such assumption can be made in case of taxing statute, and unless and until a particular entity is clearly mentioned in the statute as being exempt from tax, no such conclusion should be withdrawn. Hence, the sale was treated as normal sale only and hence taxed accordingly. Here, the taxation statute is not complementary even to Government of India also. It has levied the tax even on the governmental departments which thought of exempting the tax. So, the taxing statute is such a strict interpretation where the construction was made in such a manner even to leave tax even on the governmental departments. In the case of Mathuram Agarwal versus State of Madhya Pradesh, here the question was the validity of a particular section in the Municipal Act. This section says that if the property value or the annual rental value is less than 1800 rupees per annum, then that property is exempted from tax. And there is also a small provision attached to the section. What it says is, if the owner holds many such properties in the same municipal area, then the annual rental value of all such properties should be clubbed and see whether it is exempted, the tax is exempted or not. The High Court held that the consent section clearly gave an exemption to certain class of property owners, while the provision attached to the same section takes away the benefit from exempting from the tax. Hence, the provision is ultra vires to that section, and it was to be struck down. So here the principle of interpretation, what it is saying, while interpreting or constructing a taxing statute, the words in the statute cannot be compared with the same words while it is given a different meaning in another law. So, when we consider another case, that is Commissioner Wealth Tax versus Kripa Shankar, here the dispute was between the meaning of the trust. So, here the Kripa Shankar said that in Wealth Tax Act, the meaning of the trust is different, and in this Indian Trust Act, the meaning of the word trust is different. Here, in wealth tax, what it says, a person holding some properties for the benefit of others is called as a trustee, and the institution is called trust. So, a trustee, just like an ordinary taxpayer, must pay the wealth tax on the properties he holds. But in Indian Trust Act, it is said that a trust is created when a person holds the property of another person for the benefit of someone else. For example, if we consider A is holding the property of B for the benefit of C, A is called trustee, B is the author of the trust, and C is the beneficiary. Here, Kripa Shankar was holding his own property in trust for the benefits of his family members. He argued that he was holding the property of his own and not holding the property of someone else. So, he need not pay the wealth tax as a trustee. But the court of law rejected his argument and held that the term trust is defined in taxing statute is only applied and not the meaning of other statute. So, he is not exempted from paying the tax. He has to pay the tax. As such, we have come to the end of the video. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe my channel for many more interesting topics. Thank you.